Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions. Welcome back, everyone, to Keepers of Our Republic. This is a weekly podcast talking in depth with judges and election officials from around the country working to support our elections and democratic institutions. I'm Brooke Bergen. I am the special project manager here at Keep Our Republic. Today, I get to sit down with Judge Jeremy Fogel, who is a former federal judge for the U.S. District in Northern California. He received his bachelor's from Stanford and Juris Doctorate from Harvard, and has worked and lectured on a number of issues in the legal field. He was appointed to the Santa Clara County Municipal Court bench by Governor Brown before moving to the Superior Court, and was nominated to the federal bench for the U.S. District of Northern California by President Clinton, where he served until 2018. He is now a member of our nonpartisan Article 3 coalition, which is made up of former federal judges from across the political spectrum. And we are so grateful to have him here to talk about some important breaking news issues in the legal world today. Welcome.
Thank you. And it's great to be here.
Great. Well, there's a ton of topics I could quiz you on, and then we could jump in here today. But you were recently cited in AP News, and I believe picked up by a number of outlets, about a new development in the administration's deportation flights to El Salvador that was happening back in the spring. And I kind of wanted to focus in on that today. So before we jump in, for everyone listening and watching, by way of background, this all kicked off in March of 2025. We are recording this here in December of 2025, so March feels like several lifetimes ago at this point. I think we can all agree. So just a little bit of background for what we're going to be chatting about here today. On March 15th, there were two planes carrying Venezuelan migrants out of the U.S. on its way to a detention center in El Salvador, you might remember. A U.S. judge in D.C., Judge Boasberg, issued a temporary restraining order halting deportations of certain individuals that were on that flight, and verbally instructed the government in a hearing from the bench to, quote, turn around the plane if necessary. He later issued a written order, and the discrepancy between those two is something I think we're going to have to touch on. Instead of turning that plane around, Secretary of Homeland Security Kristi Noem made a final decision, which the DOJ has admitted in new filings very recently at the end of last month, not to turn the plane around. Instead, DHS allowed the plane to land in El Salvador. The migrants on board were detained and handed over to the authorities in El Salvador. So that incident has ignited a legal back and forth between the judiciary and the executive branches over whether the government deliberately ignored the judge's instructions. I think most of our listeners who are listening and watching know, but in the legal world, we're going to call that a big no-no. And whether those officials involved should be subject to some sort of contempt investigation or prosecution. Couple of developments in the last two days, 24 hours here. Judge Boasberg ordered Drew Ensign, a top DOJ lawyer involved in immigration litigation, to testify as early as next week about decisions made by administration officials back in mid-March, as well as an ex-Justice Department attorney who alleged in a whistleblower complaint earlier this year that then top DOJ officials told his colleagues in March that the administration actually intended to ignore court orders as part of the administration's aggressive deportation efforts. So with all of that in mind, Judge, lay the foundation for us in legal terms when we're talking about contempt? Like, what are we really talking about?
Well, let me back way up, because I think contempt is widely misunderstood. I think most non-lawyers and even some lawyers think of contempt the way you may have seen it in the movies, where the judge gets really mad and pounds the gavel and throws somebody in jail or yells at them. that actually is not what we're talking about. I mean, in fact, when judges do that, they get in trouble. They get disciplined because it's unethical to be that peremptory with people, to not give them due process. So the actual process of contempt is when a judge believes that, and we're talking here about a particular kind of contempt, criminal contempt, when a judge believes that, in this case, a lawyer has made misrepresentations or has um, willfully failed to comply with an order, then the judge can and usually should um, inquire as to what happened. I mean, first of all, determine whether that is in fact what happened or whether there was just a misunderstanding. I think one of the most important things the judge has to do is determine what are the facts. And so, was an order communicated? Was an order violated? Was the violation of the order willful? And in the course of the proceeding, did the people who were the focus of the inquiry, did they lie or did they make misrepresentations or did they act in a cavalier manner? And I think you have both of those concerns that Chief Judge Boasberg is thinking about right now. It's important to say he hasn't made any findings. He hasn't held anybody in contempt. He is inquiring as to whether there is a contempt. And since it's what's called in the law a quasi-criminal proceeding. In other words, somebody could be punished as a result of this. The people who are the focus of the inquiry have rights. They have very important rights. They have a right to know what the charges against them are. They have a right to a hearing, and they have a right to give their version of the events. And the judge has to be satisfied beyond a reasonable doubt that there was a violation. So that's what Judge Boasberg is doing at this point. He's inquiring as to whether the decision not to turn the planes around was one that was made in violation of an order that he had made and communicated. In other words, that they knew what he had ordered, they were aware of it, they chose not to follow the order, and that's why the planes ended up in El Salvador. So he's making an inquiry into that. Was there a intentional or a willful violation of an order that had been communicated? And then in the course of sorting that out, did people representing the Department of Justice and the administration, were they truthful? Did they withhold information? Did they provide information that was not accurate? Did they lie? All of these are things that he has to pursue, has to investigate in order to determine whether there was a contempt. And he has to be pretty darn sure. I mean, that's not the legal standard isn't pretty darn sure, but the reality is you don't hold somebody in contempt unless it's pretty apparent.
Yeah.
I remember in my career, I was a judge for 37 years in state and federal court, and I think I may have held two people in contempt in that entire time. And in one of them, it was a lawyer who had represented that he was going to be late to my court because he was appearing before another judge, and he had to do that appearance before he did mine. And this was a pattern. This was something that this lawyer had done many times, and so I had some reason to think that, oh, maybe he wasn't being straight with me. So one time, I actually had my clerk call the other judge. I said, was Attorney X ever there today at any time? No. They had no appearances, that they were not here. They were just late to your courtroom. So there was it was a situation where the attorney had lied, and it was satisfied based on independent evidence that he had lied. And so I found him in contempt. But I mean, that's the kind of proof you need that there was an order, they were aware of the order, they had the ability to comply with the order, they didn't. That's, I think, what Judge Boasberg is looking into now.
So because this is a criminal contempt proceeding or quasi-criminal investigation, is it the same beyond a reasonable doubt standard, or are we dealing with a preponderance standard?
No, it's not a preponderance of the evidence. I mean, since it's quasi-criminal, you have all of the same procedural rights as anyone would have in a criminal case.
Okay.
If you have a doubt as to what happened, you're not supposed to find the person in contempt.
And then, so I think I know the answer based on the story you just told, but Judge Boasberg themselves would be overseeing would be the fact finder in this quasi criminal
Right.
investigation as well.
There are some instances where someone's entitled to a jury trial, but there's a distinction between what's called intrinsic contempt and extrinsic contempt. Or rather, I should say direct contempt and indirect contempt. So if it's committed in the presence of the court, then the court has the power to adjudicate it. If it has to do with facts that occurred somewhere else, then there are situations certainly where someone's entitled to have a jury. Here, the question is all about stuff that happened in front of Judge Boasberg. Was did the lawyers representing DOJ hear his order that the claims were supposed to be turned around? Did they decide not to obey that order? They didn't obey the order. Obviously, the question is whether they had a reason to, or whether there was some procedural flaw in the order. But those are all things that involve a direct contempt. If they gave him false information directly to him, and that's a direct contempt. So there are situations where somebody else has to find facts, but
Right.
but this is not one of those situations.
So before we jump into, because you kind of alluded to maybe there's a procedural issue that the government is trying to argue in their filings is the reason why this order, whether or not it was an order, was or was not followed. We'll get to that in a second, but I want to touch on what you said, which is that, in your career, I don't want to date you, but long career on the bench, I'll dare say, you had this come up twice. I think we have an idea from Law and Order, or we were talking before we turned the camera on here about My Cousin Vinny, this idea that contempt is frequent. It's being tossed around by judges all the time because they got to keep their court in control. And that's not really the case, is it?
No, it's. I think in the AP article you mentioned, I said, and so did Judge O'Grady, who I did that interview with, that it's a last resort.
Yeah.
You try everything else, and if you can't get where you need to go as a judge, then contempt is a power that you have, but you use it very sparingly and only in the most extraordinary circumstances. And as I said earlier, there are judges who do it too much. I mean, there are judges who have thin skins and quick tempers and hold people in contempt. And I have done a lot of work in my past life with disciplinary agencies and around judicial ethics, and a lot of judges have gotten in trouble for abuse of the contempt power. So it's really something that needs to be used only when you have no other recourse. And if Judge Boasberg were to find that the administration willfully defied his order, then that is pretty serious. If you're a judge, I mean, there are a few lines that really can't be crossed. I mean, as you said earlier, the big no-no. It's like the whole premise of the rule of law is that if you don't agree with a court order or a court decision, you have remedies. You can go to a higher court. You can seek to have the order reviewed. You can have it overturned on appeal. But we have case law from the Supreme Court that even if the order is initially invalid and is later found to be invalid, you have to abide by it in the meantime, as long as you have the ability to do so. And it's interesting, and the government has pointed out in some of its statements about this particular case that the higher court later found that Judge Boasberg shouldn't have been hearing that case, that the case should have been heard in Texas. And that's fine. I mean, but at the time that he heard the case, he had jurisdiction,
Right.
and he made an order. And so if the government simply said, well, we don't care what you have to say, Judge, we're not going to follow it, that is not a situation that any judge can let go. I think that's when I say it's a last resort, I mean it's something that should be used very sparingly, but that is the kind of situation where it almost has to be used. Otherwise, the authority of the court is completely conditional. It's whether the parties want to comply with it or not, and that's not how our system works.
So speaking of, complying with the court's order, let's talk about the order itself, because from my understanding of the filings, there's a bit of contention over what the order was and
Right.
whether or not they were or were not, you know, uh, complying with it. So, a little background. My understanding is that in the hearing, from the bench, Judge Boasberg verbally made that statement of, turn the plane around if necessary. Um, but that phrase or a direct mention of a literal plane was not included in the later written order that was issued. It's according to the Department of Justice in their responses. The order itself blocked the administration from removing, quote, any of the individual plaintiffs from the United States for 14 days, but again, didn't specifically cite any of the plaintiffs that were already airborne at the time that that hearing had happened. And so my question is, does that make a difference? Does a ruling from the bench verbally versus something that ended up in the written order afterwards, should that make a difference in this case?
Well, it depends on how, I guess the first part of the answer is the fact that it wasn't in writing is not the end of the inquiry.
Hmm.
It is possible for an oral order from the court to be binding. It may never be reduced to writing.
Right.
Simple example is attorneys starting to walk out the door, and the judge says, you need to stay here, because we're not done, and the attorney leaves anyway, right?
Right.
So there's no written order. I mean, it's a violation of a court order.
Yeah.
So the question is whether there was any doubt, whether there's any ambiguity, whether the circumstances were such that someone in the position of the DOJ could have reasonably thought that their obligation was limited to what was in the written order. And I'm sure they're going to make that argument.
Yeah.
I assume that there's a transcript, that the words are there. Sometimes there's not a transcript. I mean, sometimes it gets really dicey because you don't have a transcript. So people's recollections can differ, and I think that's going to be the issue. Is like, was there any doubt that A, the judge knew that planes were in the air, and B, that he told them without any ambiguity whatsoever, you got to turn those airplanes around.
Right.
And if they can say, well, we were talking about a lot of things in that hearing, and we relied on the written order that the judge issued, and we complied with that written order, then that can raise a reasonable doubt as to whether there was willful disobedience of the court order. That's the factual thing that the judge has to determine. But the fact that it wasn't written down, turning the planes around wasn't written down, I don't think that's fatal to the inquiry. It does complicate it.
So let's take a step back and think about this case and what's going on within the larger context of what has been happening with sort of this executive versus the judicial branches of government over the past since the beginning of this year. If we are to take the allegations in that whistleblower complaint for a moment, we'll take them at face value, that we mentioned earlier in our recording. That allegation was that an unknown top DOJ official told his colleagues that the administration intended to ignore court orders as part of this deportation scheme when this was all really ramping up in the spring. So if we're going to take that at face value for a second, this appears to not be, a one-off miscommunication or a misunderstanding, a good faith misunderstanding of what was discussed in court and then a difference with the written order, but sort of a pattern of behavior, a policy decision to not abide by these immigration court orders. So what are the stakes if we have an executive branch that is in fact doing that? That wants to allegedly ignore official judicial orders as part of a policy agenda.
Yeah, well, that's a very serious question, and I think there clearly is a larger battle going on here, in which this is simply one pretty high profile skirmish. It's not just about this order and these deportees and Judge Boasberg. I think it's a much bigger battle, and I think the administration's view is, we're not disobeying orders. We are perhaps testing their limits, because we don't think that the orders are appropriate. We think the courts are misguided. We think the courts are activists and trying to block the president's agenda, et cetera. There's a lot of sort of political messaging that's going on around that, and so they will say that we are not flouting court orders literally, but we are testing the limits of the court's ability to block the president's agenda. That's kind of the way that the matter is getting framed. And I think the other side of the political argument is, wait a minute, you owe deference to courts. You don't mess with court orders. You don't mess with federal judges. And this is part of a political campaign to weaken the authority to delegitimize the federal courts. And so you have that kind of I think I've fairly stated what both positions are, and excuse me, and I think that this particular the lens through which you look at this particular controversy depends on where you stand in that particular political argument. We talk about this a lot in the Article 3 coalition. We want our input on these things to be free of politics. It's a nonpartisan group. We have judges from both parties and 5 different presidents, and the idea is to try to be educational about the structure of things. And so if you think that Judge Boasberg is one of many federal judges who are hostile to the policies of the current administration, and he's doing whatever he can to block them and obstruct them, if that's how you see this, then the way you're going to look at this particular controversy is, well, here's an example. These are bad guys. They were being sent to a prison that they deserved to go to, and he did everything he could to get in the way, even though he ultimately didn't have jurisdiction. So that's one spin on it. Another one is, hey, wait a minute, these guys didn't even get a hearing. They were just put on an airplane and sent to a country they had no connection with, and the judge said, hey, bring them back so we can have a hearing, and Justice Department didn't do it. And then they were not truthful about what was going on. I mean, so if you look at it through that lens, then that it becomes a very serious matter of, it's great concern. And I think all you can do to get around the partisanship is to just say, well, here's how things actually work in practice. That judges don't hold contempt hearings very often. that you have to have, and I tried to explain this before, you have to have a really firm factual basis that there was an order, that it was valid, that it was, or at least that it was clear. If not, it doesn't matter if it was ultimately found to be valid, but it was a clear court order that the court had jurisdiction to make. That there was willful disobedience of the order, that there was dissembling or misinformation given to the court about what was actually happening. And that would be a problem regardless of how you looked at the case politically. I mean, right. from a structural, systemic standpoint, I think that's the concern that we as a coalition have. It's not do we think the administration's immigration policies are good, bad, or indifferent? It's more is there a basic understanding of what the role of a court is?
Right.
And I think that's why this case is so meaningful, because it really is challenging the what is the role of a court. There's a different case, but similar kind of circumstances. It got a lot of publicity involving Mr. Abrego Garcia, which came out of the Fourth Circuit, and he ended up getting deported without a hearing, and also went to El Salvador. He went to the same hearing, or the same prison rather. And one of the most conservative judges I know, Judge Wilkinson from the Fourth Circuit, wrote a really very pithy opinion, just saying, well, wait a minute, you can't just grab somebody off the street and stash him in a prison in El Salvador. You have to have at least some process of determining, well, is this person a dangerous alien? Are they deportable? I mean, it's et cetera. There's a process you have to go through, and you can't just dispense with it because the end justifies the means, or because he's a bad person who you don't want in the United States. And so I think part of what we're trying to say here is that you at least have to have the process. You have to do what the rule of law requires. And it doesn't require you to be sympathetic to somebody like Mr. Abrego Garcia or the people who were deported in Judge Boasberg's case. I mean, you could agree that those are people who don't belong here and they're undocumented and they have no legal right to be here and they're gang members, et cetera, et cetera. And it doesn't change the fact that they have basic legal rights. And so the fact that you want to make sure that those basic legal rights are afforded to them, that's not taking a political position.
Right.
That's not saying the immigration policies are wrong or that these guys are great, they ought to be given a gold medal or something. It's just saying this process, this is the legal foundation. This is what our Constitution requires.
Yeah.
Right. And I think that's where the
yeah.
focus needs to be.
And I think you briefly mentioned Article 3, and I think what you and the other judges in the coalition are doing such a good job of doing, and why this is so necessary, is demystifying or addressing these this misinformation, disinformation about these previously rather benign, rather boring, if I may, legal processes. We both attended law school, obviously, and spent a great deal of time learning about due process. What is the process that is due to each person? And the average person watching news, reading a news article, hasn't had that same sort of background in education. That's not necessarily bad. I don't know how to do heart surgery, and that's fine.
Right.
But thank God. But when you don't have that background on these sort of heavy legal topics and these procedures, then it's really easy to be led astray or to not have the information necessary to weigh the information you're receiving, right? Like you don't have the background.
Yeah, and I would have to say that we, the legal profession, bear some of the blame for that, because we speak in professionally significant language. We have this sort of mystical
Our
vocabulary,
legalese, yeah.
legalese, due process, and all that, and it's like that we have to translate that. So what does that mean to somebody who's not legally trained? What does it mean to just a member of the community?
Mm-hmm.
And it means, and I have sort of my own elevator speech about this. I mean, somebody says, well, what is the rule of law? Well,
Give it to us.
It means, for one thing, it means that if there's a legal dispute that's presented to a court, that it's based on evidence. There's actually evidence presented, and there are statutes, or there's precedent, there's law that governs how the case is going to be decided, and that is how the case is decided. It's based on the law and the evidence. And you can imagine, I mean, there are plenty of places in the world where that is not how cases are decided. I mean, sometimes the way cases are decided is, well, what does the government want,
Yeah.
or, what clan do you belong to, or who's your cousin, or who's your brother or sister?
Who's got money?
Like,
yeah.
Who's got money? We have more of that than I would like. I think economic inequality does play a factor here, but I mean, at least the template that we operate under is you have evidence, you have rules. And so that's the first foundation, is that's the way we make decisions. Yeah. And the second part to what we were just talking about is that people have a right to be heard. And that's really what due process ultimately means. It just means that before somebody can snatch you off the street, before somebody can put you on an airplane and send you to El Salvador, before somebody can take your property, before somebody can put you in jail, I mean, you have a right to be heard by a neutral and impartial judge and explain why that shouldn't happen. So that's the second prong. And then the third one is that the people who make the decisions, the judges, are ethical, that they follow the rules, that they do it without fear or favor. That's part of the oath that federal judges take. You promise to apply the law without fear or favor. So, I mean, I'll just talk about Chief Judge Boasberg for a second. He has been like one of the principal targets of the administration. They called for his impeachment. They've received lots of personal threats. I mean, this is somebody who's been really targeted, and yet, this is somebody who served with great distinction, is admired by people, colleagues, and people who appeared before him, worked with him in both parties, and in the face of all of that, he's proceeding with this contempt hearing because there may have been a line crossed, and this is what he's trying to find out. He's going to have a hearing where he tries to determine whether that line was crossed. And I really respect that because he's doing what he has to do. He's doing what judges are supposed to do, which is apply the law without fear or favor. And that's I think when you're a citizen and you realize what would our country be like if you didn't have that. Mm-hmm. You had cases that weren't decided based on evidence. If you didn't have a right to be heard, if you had judges making decisions based on political pressure and who was in office at the time, I think we can imagine a whole list of very horrible things that would lead to. And so,
yeah,
that's why it matters. And I think we have to do a much better job of making that personal for people who are not part of our bubble.
Right.
And I think that's one of the goals that the Article 3 Coalition has, and I fully support.
Well, Judge, thank you so much for taking a deep dive on this topic with us. It's incredibly important. It's nuanced, and I don't think it's getting the coverage that it needs. So we really appreciate you taking the time with us. For everyone listening and watching, I will link to some of the articles the judge was speaking of that he was cited in if you want to read more, as well as some of the recent filings on this issue. And we will be back next week, be talking with one of your colleagues on that judicial impeachment issue. So thanks for teeing us up quite nicely on that. And everyone, enjoy your week. We'll see you next week.
Thank you for having me very much.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.